third-party proceedings, interpleader proceedings, and also to tell us what steps one is required to take before instituting an action. So we take their assignment in bits. The first aspect of the assignment is to discuss third-party proceedings. In the first instance, why is it even called third-party proceedings? It means an action or an application brought by someone who is not an original party to a suit, or who ought not to be a party to the suit, but due to special circumstances, he wants intervention of the court to exculpate him from liability. So just look at the ingredients. In the first place, this person is not an original party to an existing suit. So that's why we call him a third party. In other words, a stranger. But this is a stranger with legal clothing. That's why he is called what? Third party. He is not called a stranger. He is not called an intermeddler, a meddlesome interloper. He is not called that. But because he wants the court to come to his aid so as to save him from any likely liability or any likely suit against him, especially double liability. So the issue of third-party proceedings is more epitomized when you talk about the interpleader proceedings. In interpleader proceedings, which can be divided or approached from two perspectives, it simply means a proceeding whereby someone who is under a liability does not know who he owes the liability to. He is under a liability, but he doesn't know who he owes the liability to. He may be a person in possession of something that he doesn't know the owner. He doesn't want to be accused of stealing. He doesn't want to be called a bad name. And he doesn't want to have liability over that. So he seeks the intervention of the court as a third party. Now we take it from the first one. If he is under a liability, but does not know to whom the liability has accrued. And the question is this possible? The answer is yes. I'll give you an instance. Let's say you're staying in a property, you're paying rent to the landlord, but upon the demise of the landlord, the son of the first wife will come for rent. Son of the second wife will come for rent. Maybe their mothers will also come. You don't even know who to pay the money to, right? So such a scenario can occur. So the best way to determine who you are liable to is by what? Interpleader proceeding. Is by interpleader proceeding. Now in that interpleader proceeding, what we're going to do is to join every contestant, sue them, in quotes, as what? Defendants. In as much as these ought to be claimants, but you don't know who is a claimant. You don't know who the rightful claimant is. Maybe they have a will, you have not read the will, you don't know anything about their will. Maybe there is a family arrangement whereby they have distributed rents, how to collect rents among themselves, and you do not know. So the best thing to do is to do what? Put them together and sue them, make them defendants in your interpleader proceeding. We'll look at the mode later. So when the court takes evidence, most likely affidavit evidence from all the parties, your own is simply to do what? To stay aside and watch. In as much as you're a temporary claimant, suing people who ought to be claimants, but because you don't know who a claimant should be from among them, you call them what? Defendant. So when you sue them, the court will look at their evidence and decide one way or the other who is actual who the liability actually accrues to. So in that way, that person becomes what? The proper claimant. And the determination of that court amounts to what? Final judgment. In as much as your application could simply be a mere application, it could simply be an interlocutory application, or you have gone further. If there is no suit pending at all, you have gone further to do what? To file an originating summons for the court to interpret and tell you who you should pay the money to. So any decision reached by the court becomes what? A final decision. Now again, you can have interpleader proceeding when an action has been determined, judgment given, and the execution levied, but before the different articles are sold on auction. Somebody wakes up to say, no, that car he wants to sell does not belong to the defendant, the judgment debtor, it belongs to me. What is he trying to say? He's interpleading his cause in his favor now. So under that wise, he is not even the one to stand up to say, I'm bringing an interpleader action. What he simply doing is to do what? Inform the sheriff. Make an application, make the proper application. When you look at the format, possibly one of the schedules, you will see the mode of bringing that action. So the sheriff brings that action in his capacity as what? The sheriff of the court. In other words, he's like a peacemaker now. He's like a peacemaker. Why should that be? It's because the legal title to the property already different is vested where now? In the court until it is sold. So the sheriff represents the court. Right? The sheriff now becomes the eyes and the hands of the court. In as much as the judge is there, the judge cannot descend into the arena of dispute. So the sheriff takes out this action for you, the claimant, to come and show that the car levied in an execution does not belong to the judgment debtor, but it belongs to you. Right? And then, of course, we who assess will do what? Must prove. So, for somebody who is saying the car belongs to me, what and what do we expect him to prove? Document of the vehicle. What else? Well, then the document. What about the document? He must be able to provide documents showing that he is linked to the car, that is linked to the ownership of the car. So if he hasn't done proof of ownership, he has to at least show what? Receipt. To show that he bought it from Mr. A. Mr. A transferred the documents, and the documents are still in the name of Mr. A. What else would we expect him to prove? We are talking about a judgment already given against a defendant, judgment debtor. And the car has been taken from the custody, which means that car was found in the custody of who? The judgment debtor. Then what are you telling your client to prove? Are you not getting the clue? What should you do next? What is your next evidence? What other evidence should you adduce? You have shown papers. What else?
You show evidence of how the car got.
How did the car get into this man's hand? That's it. How did this car get into his hand? Did you sell it to him? If it was sold to him, then you have no case. Did he borrow it? If he borrowed it, then you have a case. So you must one way or the other show how your car got into the hand of the other person. Now, the duty of a sheriff is a very fragile one, because a sheriff may be liable for wrongful execution. So which means when a sheriff is taking out a sheriff interpleader action, he's also doing what? Trying to defend himself, to justify why he destroyed the car in the first place. Right? Because if maybe his reason was simply like, I've been seeing this man driving this car, and now he has parked the car in the house of Mr. C, and the sheriff will just went straight to Mr. C's house to destroy the car. Would he be right? He would not be right. He always acted on what? Speculation. imagination, which is not allowed to do. That's why we say that the duty of the sheriff is a fragile one, so that if he had wrongly destroyed the car and anything had damage in the process, he will be what? Liable. He will not even say, I'm doing it for the court. It's just like the duty of a trustee, and we said that a trustee's job is what? A thankless job. You do all this, in the end, you have the liabilities upon you. You may not even be paid as abscond. As a trustee, you're not even entitled to be paid. The same thing happens to a sheriff. So that's how sheriff interpleader operates. So the next thing we want to look at here now is the rules, the legal framework for this interpleader. For the stakeholder interpleader, the legal framework is the rules of the court. Every rules of the court has provision for stakeholders what? Interpleader proceedings. The rules of court will tell you how to make the application, whether you're coming by way of ex parte or you're coming by way of notice. It's the rules of court that will tell you that. But for the sheriff interpleader, it is regulated by what? The Sheriff and the Civil Process Act 2004. It's regulated by the Sheriff and Civil Process Act 2004, specifically Section 34 thereof. Section 34 thereof stipulates what a sheriff interpleader is all about, and it also stipulates the conditions and how such an application or an action or proceeding can be instituted in the first place. What to do when you want to file an action in court. For instance, the proper party. A client has consulted you, and in the first place, there has to be what? Consultation. Except you're doing the matter pro bono, there has to be what? Consultation. And that's why when a client comes to you after telling you his story, maybe the first day may be too tired, you may not even understand the person. You ask the person to go, come back and then give the person an appointment. And if the person is late charged, you can ask the person to do what? Put your story in form of writing and bring it so that you can read and digest it, make some marks. On the next adjourned date for the invitation, you do what? You raise some questions. You start asking your client some of those questions. And when you're okay that you want to go ahead with the matter, you now ask the client to do what? Write you a letter of engagement. Don't forget that. A client is consulting you, there has to be what? There has to be a letter of consultation, because in this client, we are highly punished. But in United Kingdom, that if say this kind of issue could have landed me into trouble, but I have a defense. You understand? And you know that there are some clients that they don't care if you get into problem. They don't care. So that's one of the things you need to consider, that consultation. And then after hearing the story, settle for the cause of action, settle for jurisdiction. I'll just give you a couple of authorities on jurisdiction, and then I will tell you two things you didn't mention. Then on jurisdiction is said to be a fundamental life wire of every action. It's a fundamental life wire of every action. The effect being that any matter conducted without jurisdiction, no matter how brilliantly conducted, that matter becomes what? A nullity. So in the case of Raji Ashade against Governor of Lagos State, Raji Ashade against Governor of Lagos State, 2024, 4 Nigerian Plea Law Report, part 1928, at page 257. At page 257, I'll just tell you what the court said about jurisdiction. This Court of Appeal Lagos say that jurisdiction remains a threshold issue In the realm of judicialism, jurisdiction remains a threshold issue in the realm of judicialism, as the first eight erigo and the live wire of all proceedings in a court of law. Its usefulness cannot in any way be easily waved away with the back of the hand. The lack of jurisdiction in any matter, no matter how brilliantly conducted, we end at absurdities and nothingness. So I can quote this thing and it becomes a question in the exam. So all these, I need for you to read this back and then ask yourself, who provoked the court that the court was speaking this big grammar, and what was the nature of the provocation? Then we also want to hear from Supreme Court the latest decision of the Supreme Court in NASCO against Bello. NASCO against Bello, 2024, for Nigerian Criminal Law Report, part 1928, at page 239. 239. Here, the Supreme Court was dealing with issue of jurisdiction whenever it is raised. So, which means that the issue of jurisdiction can be raised at any time. So, at the point in time when you're being consulted, that's the proper time to settle that issue by way of proper parties, territorial jurisdiction, the kind of court you're going to, the monetary jurisdiction of that court, and the subject matter jurisdiction of that court, because the issue can always come back and spoil the good work that you had already done. Here the Supreme Court says, where the issue of jurisdiction of a court is raised and questioned, especially in a preliminary objection or otherwise, utmost and primal attention must be accorded it before other matters or the substance thereof can be considered. Where the jurisdiction of a court is challenged, the court must first and foremost assume jurisdiction to determine whether it has jurisdiction. That's another angle I want you to know. The mere fact that you just come to court flagging it, hey, my lord, you don't have jurisdiction. And my lord is okay, move your motion. He said, my lord, I can't even move the motion. He can't even move the motion. You can't even hear it. You don't have jurisdiction. The Supreme Court said a court of law must first of all do what? Assume the jurisdiction to determine whether it has the jurisdiction. Because if it doesn't assume the jurisdiction to hear your application, who else will hear it? So it cannot work in your head. You have to make the application, and the court will assume the jurisdiction to hear it first. What if after hearing it and the court discovered that you were wrong? Right, so that was what the Supreme Court was talking about. There are so many authorities I could have cited on this, but because of time, we'll just move on. And now, fundamentally, one of the things you're going to meet at the law school is, when you are having consultation with your client, the first thing that comes to your mind is the ethics. What is the ethical standard? The ethical standard. First of all, thou shalt not deceive thy client. Not people who will say, oh, I win this case, there's nothing in the case. I know every judge, I can call the judge on phone. That's one of the ethics of the profession. You have to be true down to earth to tell the person this is what it looks like. If your client does not have cause of action, forget about the money. It will come when it will come. It mustn't be from that matter. So if your client doesn't have cause of action, actually they say, no, you don't have a cause of action. I have, for several times, advised some clients who came to me and said, look, you can't fly, you don't have a cause of action. You said, just write, I said, if you want me to try it, write me a letter. In that letter, tell me what I have advised you to do. And then tell me you want me to try. So by the time the letter comes, I look at it and say, oh, I'm so sorry, by our ethics, I cannot. So you're just wasting your time. It does better go to another person. So every principle of law, every step being taken by a lawyer, there is what? Ethics. And then again, Try to avoid champati. Try to avoid champati. Champati is abateke. You know, maybe there's nothing there. Okay, we can buy the trouble. We can make the trouble. We know who is who in this town. We don't do that. That's a professional misconduct. Sure, reaction notice. Now, there's a question I asked my brother. Why would that reaction notice be important for everybody to obey? Because NNPC is involved. The issue is not because it's a government corporation. No. It's not because it has connection with the government. No. It's because the statute establishing it has said so. But then, the judicial attitude towards reaction notice is not automatic. It's not something that is, must be obeyed as a matter of course. The court has first of all to do what? Look at the circumstances of the case. How much time did the defendant, the claimant have as at the time of institution of the action? Let's say, for instance, now, Constitution has said that I have the right to own immovable property, and they cannot acquire it without first of all doing what? Compensating me. Right, and all of a sudden I see a pipeline dividing my land, maybe even going into your parlor. Maybe they want to break your parlor, because they are laying pipeline. It's important for the economy, is it not? But my right supersedes. You have to respect my right first. So what do I do? What do I do in respect of that? Do you allow it, tell me to sit down and they arrive reaction? By the time 30 days is gone, they have finished what they're doing. Your house is already down. And there's nothing you can do about it. So that is why most rules of the court provide for expedited actions or emergency situations like this. For instance, when you look at I think that's Order 3 Rule 2 of Abia State High Court Practice and Procedure, that's what they call their own rules, 2021, you discover that in order to handle a situation like this, the rules of court tells you that you can do what? Even go for injunction without filing the suit itself. Without filing the suit. Why? Because it wants to have a situation like that under check and balances. So it's not because somebody is a corporate body, the person will now trap upon your right. Afterwards, there is what? Equality before the law. But where the facts of the case is so clear, there is no immediate urgency or threat to your arrest, what you do is that you do what? You obey that reaction notice and serve it. Even if a public officer is involved and has committed a wrong, how much time do you have to sue him? How much time now? 3 months. With any year, nothing will happen to you. All right. So all those laws are there mostly for expediency's sake. And now again, look at the reaction notice in respect of subsidiary companies. NNPC has subsidiary companies like NPDC, which has now been changed in the nomenclature. Now the question always arises: is this company that is limited entitled to reaction notice? The answer is what? No. Even though it is a subsidiary of a parent company that is entitled to what? Reaction notice. Why? Because upon incorporation as a limited company, it becomes what? A different personality under the law. It now enjoys the gap of a personal entity known to law. Wait, what is the authority now? What is the authority? Solomon. It's not Solomon, it's Solomon. So, if you like, call Solomon, you see answer. All right, so far so good. We drop the current here.